from the Dutch DPA, and with an expert in internet and telecom. And to my right, you have Mr. Damian Clifford, working at the KUL, and where you're looking at the interesting issue of monetization of online behavior. So this is very relevant for our panel today. And last but not least, we have the moderator, so the person who is managing the whole thing. And this is Mr. Niko Härting, professor of the Hochschule für Recht in Berlin. We have another panelist who is supposed to join us later on, the parliamentarian, the MEP, Mr. Axel Voss, but I understand that he will join in 5 minutes or so. So let's start this panel, which is called Disconnecting Frameworks, ePrivacy, Digital Content, and the GDPR. And I say from the Commission perspective, I would not have chosen this title, of course, but this is what is going to be discussed today. And so, Niko, Härting, the floor is yours. Thank you very much.
Thank you very much, Olivier, and very happy to see so many people in this room. And let's start discussing the very plainly the efforts to you. You have at the University of Leuven, and you have followed the discussion about the Digital Content Directive, and I have however, one aspect of the proposal is problematic, since it will be applicable to situations where a crisis pays for the digital content, but also where digital content is supplied in exchange for a counter-performance other than money in the form of personal data or any other data. The EDPS, that is strong, warns against any new provisions introducing the idea that people can pay with their data the same way as they do with money. Fundamental rights, such as the right to the protection of personal data, cannot be reduced to simply customer interests, and personal data cannot be considered as a mere commodity. Disconnecting frameworks, there we are. The European Data Protection Authority says that there is an inherent contradiction between you can only have one fundamental right or the other monetization. What's your view on that?
I suppose some of this question relates to the positioning of data, or including personal data, in the proposal as a mere commodity, and whether that is so, and yes, I think it is. And then I suppose, is this in line with fundamental rights in the GDPR? And I suppose in relation to this, I'd like to maybe, I think there's a lot of lines you can go down here, but I think I'd like to specify a little more on the notion of freedom and consent, because I think that this is strongly related to that idea. So we know in Article 4.11 of the GDPR, consent contains certain conditions. So it has to be freely given, specific, informed, and unambiguous. And I think this freely given stipulation is then further qualified in Article 7.4. And it says, where it says that freely given, in assessing whether consent is freely given, utmost accountants shall be taken by the performance of the contract, including provision of the service, is conditional consent. And essentially, the data processing that is not strictly necessary for the performance of the contract should not, that really has an impact on the interpretation of the legal. The digital content proposal fundamentally challenges this, I would say, because in the original proposal, the positions of this personal data and in the Parliament report modifications, although it removes the term counter-performance from the main body of the text, it does say that data, the surrendering of data can be made provision of the service is dependent on consent, despite such consent not being necessary for such performance. So I think that there's a clear challenge here in terms of the interpretation. There is another point that I'd like to raise here. I mean, we're comparing secondary frameworks here, whereas I think the Digital Content Directive as a proposal in secondary law in itself has to respect the Charter. So we're talking about Article 52.1 on the limitation of rights, which essentially says that it has to be provided by law, it needs to be proportionate, it needs to be necessary. And there's a real question about how the Digital Content Directive accurately satisfies that test. And not only that, but also Article 8.2 of the Charter, so Article 8.1 is the right to data protection, and Article 8.2 provides further specification. So there is a clear problem in terms of how the Digital Content Directive may actually satisfy the balancing there. So I think maybe a question that comes out of it is if your position control as the essence and about the right to data protection, how, given the apparent deviation from the GDPR, which I will assume that the GDPR does respect Article 52.1 of the Charter, given those deviations, could the proposal actually respect Article 52.1 and Article 8.2? And if it went before the court, how would they incorporate it?
So you say there is a clear disconnect between the GDPR and digital content. What would be your answer to the disconnect? I mean, we have the GDPR and we will keep it, I guess. What would be your answer?
Well, I mean, I think the difficulty really here is, well, I mean, I think the GDPR is a fundamental right framework, and it is here to stay. It took us a very long time to get what we have. I think that is what we are going to maintain for at least the next 20 years. I think the Digital Content Directive, if it is not aligned with the GDPR, it's a question of whether it would respect the Charter. So I think even the passing of the directive, I mean, if it went before the court, it would be interesting to see how they would deal with it, how they would interpret its adequacy vis-a-vis the condition or the legitimacy of the actual piece of legislation. So, and we've seen that the court isn't exactly afraid of with the data retention directive. So I think there could be issues.
Olivier, I would be surprised if you agree.
I think you very well pointed out some difficulties in the way the proposal was drafted and some of the misunderstanding that it has created, because you have to see the starting point of the Digital Content Directive. The idea was to provide additional rights to the consumers for products or services that they started to use without paying money. So this is the starting point. So the starting point is to give additional rights. But because maybe the wording was not so clear, this issue of data as counter-performance has appeared in the debate. I think we should rather speak of consumer-provided data in the context of a service, etc. That would trigger then this additional guarantee. But it is absolutely, and this I want to fully share the point of view, that first of all, the GDPR is there to rest because we don't want to start a new negotiation for the next 20 years, at least. Second, the consent as it is defined, and the fact that the consent should be freely given, that it should be a tight consent in line with the GDPR has to apply fully, and anyway, the digital content is a directive, so we have a regulation with the definition of consent and what it means. So I think it's for the legislator now with their wisdom working on the text to indeed ensure the consistency with this notion of consent under the digital content.
Well, as you mentioned, there happens to be a legislator on this panel.
So at first, if you would ask me when we will have a new GDPR, I would say we should start immediately on it. But so on this relation between GDPR and Digital Content Directive, we tried as an EPP group in this case to avoid, to mix both instruments, but we have a kind of a strong opinion on it that we should connect the GDPR with the Digital Content Directive at first in a general way, and this is what I would say would be okay, but in a second way also having this connected with the question of conformity of the product. And this is what I would say would probably lead to totally strange results at the end, because for me the data protection regulation is one structure in one own regime, and if we are now starting to interpret this in a different legislative tool then or instrument, then probably the interpretation of the GDPR might be complicating the situation. As a legislator, and there we have been more than less unity in saying we don't like really this concept of data as a counter-performance. Because if you're thinking into the future and then buying water with data or whatever, we don't really like this, and therefore we try to avoid this concept. But in reality, of course, we are seeing there are contracts where you exchange data somehow, and therefore we are trying to get remedies on board and saying, so what should happen if this is not in line what was said before. So at the end, I would say the EDPS is right. We shouldn't encourage the contract situation in saying, oh, if you don't have money, we can spy on you half a year or 1 year or whatever. And also, sometimes I would say probably we should also avoid, if I'm buying new shoes, that you have to fulfill a kind of a data protection declaration. And so this is what I would say the EDPS is right here in this point. I wouldn't mix two of these both tools, but I'm not sure if I will be successful at the end. There might be a kind of a general link, and this is okay, but with this conformity it depends a little bit on the majority at the end. But again, the requirements for consent in the GDPR has own rules, and the consent in a contractual situation has totally different requirements. And that's why I'm fearing a little bit that this interlinking of something would lead to a kind of a disastrous interpretation of everything. So, but you ever should have in mind, for my ideas, I should have a majority. If I don't have this, then we will go a different line. But once again, I think we shouldn't encourage, especially people who don't have the money for some contracts or whatever, or some goods, and then saying, oh yes, you can pay with data, and this means we are surveying you the whole time. So that's why I would say in this case the EDPS is right, that we shouldn't encourage this situation.
Axel, this is a very interesting point that I would like to to put it in my words, you could argue that that as soon as you accept that personal data is a currency, you encourage people who don't have other currencies to pay with data. Mm-hmm. And then you sort of
a slight warning. I think that there is an issue here.
Just notice that I've done something awful. I haven't asked the ladies to speak first. So we have for that. Bojana, and we should say we have been working together on ePrivacy in connection with the study I did for Civil, that you're president of, I was just wondering, is there maybe a connect between certain suggestions in connection with privacy and digital content? We have this proposal by the European Parliament on cookies. They are proposing that the website operators should offer cookie-free alternatives. The website operators, for example, newspaper publishers, argue, well, this means we have to offer content as paid content. Do you see a connection there?
So of course there is a connection. Listen, if Niko is asking the question, there must be a connection. And what worries me, and I have to speak very openly here, is that these all issues and interconnectivity are becoming incredibly political. And I would like to take a sort of a different slant, and that is one that comes from businesses and organizations in private and public sector who are trying to comply with these requirements and rules. And so, can I sort of first say something that sort of is, has been mentioned here, and that is the relationship between various laws that are being proposed and the GDPR, which we still see as a principle-based main piece of law that is governing use of personal data. I think we run into real problem here that we are not allowing this GDPR, this data privacy framework 2.0, to actually live and be proven to work and be proven to be a good opportunity for all businesses and public sector and SMEs and large organizations. I think GDPR, despite everything you have heard and you might be hearing, is indeed an opportunity for us. I'm now talking to members and center the organizations I work with, that this is an opportunity to actually get privacy right, to make it a business issue versus just a legal compliance, to make privacy a matter of trust. And I think by having sometimes contradictory, overlapping, or unclear or confusing rules really doesn't help practitioners on the ground. There's a huge effort out there to ensure compliance with GDPR at the moment. Organizations are really going behind this and getting behind this. Certainly what Commission has just published today, this sort of huge amount of documentation is certainly going to help. I was yesterday, and I have to tell you this, at the conference that we organized with the Irish Data Protection Commissioner on how to deliver accountability under GDPR, because she felt the Irish market needs that sort of best practice sharing. And you know, there is huge amounts of people out there who don't know where to start, and it's 3 months before GDPR. And what worries me, Niko, and really what worries me, is that we are now slightly confusing this discussion for practitioners and adding to the legal uncertainty and to SMEs confusion by these rules which are not quite fitting together. And I'm not an expert on content directive, but I can see the issues. I also think we're sometimes again elevating, and this is Brussels, and I appreciate, and you know, Axel, it's you know, we've got politics to think about here as well, but this isn't about politics. This is really about how we manage our digital economy in Europe, how we manage compliance, how we manage data. And you know, data is an asset. It's not oil, no, my friends. It's actually akin to environmental protection. We must ensure sustainable information that is trusted, responsibly used, can be shared responsibly, can flow around Europe, because that's what's going to gear European success. And that's how I see it. And now we are kind of muddling this a little bit. Should it be paid content? Should it be not paid content? I'm not sure we can reverse the internet. I don't think so. And I kind of don't think that this is this is what we should be doing here, legislating. I think we should be giving GDPR a chance, giving GDPR opportunities to develop. And what do I mean by that? Codes of conduct, core regulatory mechanisms, accountability mechanisms, rights of individuals that are being empowered, organizations which are required to do more, which are going to be proactive about use of data. And that's what I would really call for our focus at the moment. But I know this panel isn't about that, but I have to say that because it's like a cry for action, really. And I know we're in Brussels, but I'm telling you, people out there in Europe, they really want to get GDP right. And I think, Axel, despite you and I share so many views, I don't think we need to change this. I think we have to take the GDPR elements and really run with it and make most of it. Certifications, accountability, codes of conduct, this engagement between DPA and organizations, and really help SMEs who are utterly confused at the moment. So that's not quite the answer to your question, but I don't want to be drawn into politics, if I may.
Sure, maybe it's time, or definitely time to bring you in at this point. Sure, you are working for well, I'm not even trying to pronounce the Dutch title of the authority that you're working for, is the Dutch Data Protection Authority, and there, if I understand correctly, you're specifically working with the telecom industry, not for the telecom industry. I won't say against the telecom industry, but that is the field that you specifically address. First of all, I would be curious if you share the view that companies are enthusiastically trying to comply to the GDPR. That was just Bojana was saying. Is this also your impression? This would be my first curious question. And then the second question, whatever you say to the first question, it certainly does create a lot of effort and work in businesses in Europe. And the argument that Bojana was just making was, say, well, now that companies have done so much to comply with GDPR, do they have to now to go through all of this again for ePrivacy? And I would be interested, I mean, you will have heard these arguments before, and I would be very, very curious what your view is on
that. So let me try to be modest first. So we are a supervisory authority. We are given a hand of cards by politicians. And sometimes the politicians just cannot agree. So they give us completely conflicting arguments in one and the same law, and we are forced in a position to explain which of the arguments should prevail. This is not a good position for a supervisory authority. So that's our problem, you can think, but this is a major problem for industry as well. And in what we ask from politicians is give us a clear framework. You know, be brave, take a decision, stand by it. Don't add 20 conflicting considerations to a rule in the directive or regulation itself, because then we're stuck how to explain it. And it's not just us, the supervisory authorities that are getting headaches trying to fit squares into circles and trying to explain this, but it's a major problem for industry as well, because large companies can afford lawyers that can frustrate any enforcement for the next 8 years, because they're already telling us we'll go to the European Court no matter what. We'll first go to the European Data Protection Board, then we'll go to the European Court, and then we'll slightly change the business model, and then we'll start all over again with the same dispute. And this is awful, because this will hurt SMEs, because the DPAs usually go after market leaders, semi-monopoly companies that can afford a fight with the DPA, but sometimes new technology is spreading really rapidly. A really small company like WhatsApp, when we started investigating WhatsApp, they had 5 people working in California, and we called them and they said, you mean what, Europe, data protection? We don't have a lawyer, there's just the CEO and 4 technical guys here. What do you mean, do we need to comply with Dutch data protection law? And within a year, they had 1 billion customers worldwide. So sometimes, as a supervisory authority, we have to address really small companies without lawyers, without budget for lawyers either, if they provide free services and don't have the market share yet to earn enough advertising income. So that is unfair. So our interest is clear rules that do not conflict each other. I completely agree with Bojana. So that I have to start with that. So the enthusiasm to comply. There's okay, we have to look at the past 20 years. The GDPR does not change the rules in any completely dramatic way. I think a lot of consultants are selling myth about drastical changes and dramas and fines if you don't completely overhaul your businesses. So we have to first answer the questions, how well have companies complied with the existing rules in the past 20 years? Well, unfortunately, not enough. You may blame us as supervisory authorities, but you could also ask the politicians, did you give enough money to these supervisory authorities? Is it really possible if you're a supervisory authority with, let's say, 5 people staff to make sure that all the companies in your sector are compliant? I mean, this is, we could, I'll take some blame for not being active enough. We try, really, we try. But then, sorry, and I'll stop there. But we have another problem, which is that privacy law is administrative law. The burden of proof for a data protection authority to actually provide convincing proof of a violation of the law is extremely high. So when we start to enforce, we do an investigation, we publish a report of between 100 and 150 pages with endless footnotes and documentation to prove every point, because a judge will look at a flimsy report, less than 100 pages, and say, you haven't proven anything, you know, I'm rejecting your complaint. So it's the combination of this structure of administrative law that forces us to basically, the Dutch DPA now has 100 staff, we can maybe do 20 serious investigations per year. This is terrible. We would like to do more, honestly. But the burden of proof is so high, and with the upcoming fine regime it will be even more difficult, you know. So there is a lack of compliance. But I'm not sure we're completely to blame. I'll stop there.
Okay, thank you, Sjoera.
Yeah.
I think it's very interesting because many privacy debates are sort of very extreme views clashing. One side always says we can't get enough of privacy, let's have more. And the other side says the whole industry of will die. In between there's very little space. And why do I say something sure that probably most of us can agree on? That is, please, legislators, be consistent. And I have to ask you, Axel, now, because there is another demand that goes into your direction. Why can't you legislators be consistent? And what are you doing with this privacy that might also not be quite in line with GDPR?
So the example of ePrivacy is not a very good one for being consistent and have a consistent legislation. Even if you would like to have this, sometimes I have the feeling if politicians are reading a headline like ePrivacy or data protection, then they can't change their mind and just going for it, protecting without thinking the individual in a way what I would say is exaggerated. And not being creative enough to give a real answer to the challenge of a digital revolution. If you're looking to the GDPR, I would say this is the old structure of the 80s. We are taking these and answering the digital revolution. And what we are doing is taking the digital revolution and putting these into a scheme of the 80s, and instead of differently and saying, oh yes, we have to comply with the digital environment and revolution, and so we should go on and probably rethinking about the values, what we should change, because this digital revolution is a kind of we are thinking as a national legislator or regional legislator, but data means global, and this is all over the world. You can offer something, etc., etc. And now, and what is totally frustrating me, and probably I'm not the right one always to ask for, because I'm criticizing what we are doing, especially when it comes to ePrivacy. Not giving GDPR a chance, and not really knowing if ePrivacy will come to into the light and to live with it. I don't know what is left for the GDPR at the end. And so why we couldn't wait a little bit longer to see how the GDPR is working, and the first legal instrument after the GDPR, this is for me a kind of a terrible signal, is saying, oh, we are not interested in the GDPR, we are doing a second data protection wall for a special category of data. And this is totally nonsense, and from my point of view, this has nothing to do with a kind of a consistent legal system. And now, to differentiate the requirements for consent for metadata or communication data and the totally different requirements than for the consent for the data protection regulation. And this is confusing everyone, and this means for me as in a consequence also that the same data probably underfalls two regimes with totally different requirements, and again, as a result, health data probably might be less protected than these dangerous metadata in communication. And this is such a nonsense at the end. And so I'm fighting, or I'm discussing, negotiating for this. Yes, we should be more consistent, and why we have to build up a new data protection for these data, like this metadata, communication data, instead of using the GDPR and probably add the sentence, make the communication confidential. And that's it. I would say probably you get a better confidentiality if you're just saying you have to be take care about the confidentiality of communication. Otherwise, you will face some fines. And then companies probably are doing everything what they can do to be more in compliance to this single sentence, instead of having a kind of a very difficult reading legal instrument where you don't know what this means, especially the link to the GDPR, etc. And this is what I'm complaining about. Sometimes, of course, people are saying, oh, I'm not interested in privacy, I'm not interested in data protection. No, I would like to have data protection and I would like to have privacy, but this has to be balanced with a digital world and with all these possibilities what you have already in place. And therefore we should rethink, I would say, how we can come forward, not to hinder innovation and at the same time guaranteeing the fundamental right. And this is what I'm missing, being more creative and as a legislator, and that's why I would say, yes, I'm also asking for more consistency in these legal instruments, but so far I don't have the luck for convincing people, so we have to wait a little bit what will be the outcome at the end, but I'm crossing still my fingers that one day they will see, oh yes, GDPR is not that bad and we could build upon it something, but not in a separate line.
I think at this conference with 1,200 participants with very, very different views. And none of us would be here if we didn't, if we were of the opinion that privacy was not important. I think this is something we should always take for granted and accept that both can be true, that people can value privacy and take completely different views of how privacy should be protected. I think that was a very, very important common ground that we should always try to find. We were talking about connections, and maybe disconnections in the last minutes. Helena, this is now your you are working for Mastercard, and some of you may have wondered, but what has Mastercard to do with, well, certainly not with digital content. You have a point there if that was the question. But what does Mastercard have to do with ePrivacy? Where is the connection? Or is there also a disconnect?
No, I think there's a true connection. Let me first react and say that privacy has become business differentiated. I think the panel here is right. So, and that is why companies are investing so much in GDPR compliance, because they understand that privacy is important. Now, what we're looking at, of course, indeed, as Sjoera also said, we need consistent frameworks. Regulators need consistent frameworks. Businesses need it, and even individuals. If they have data portability rights, they need to be trying to simulate data portability rights, because it's not data that completely purchased. So that's, I think, what we're looking at with ePrivacy and GDPR and the other frameworks. Now, I think one of the problems is that the scope of the ePrivacy regulation is much broader than the directive.
Yes.
And so what we are seeing that suddenly a lot of new services and new data streams are covered within the ePrivacy regulation. And on the other hand, we see that consent is still the basis, and the exemptions for consent are very small. So the exemptions are really still focused on the old ePrivacy directive scope, and not on the new scope of the regulation. So I think that is where there's a big disconnect, and where we need to look at. Now, what does this mean for Mastercard? And let me just get some examples. If you use your credit card in Belgium today, and somebody uses your same credit card number in China, that will probably get refused. And you'd like that to get refused. And that is because the system picks up that that payment is in China, when the same day you were actually in Belgium. So there are some essential and useful uses of location data that everybody wants. And it also has to do with the fact that payments, for example, are online, there's lots of online fraud, there's identity theft. So we need certain extra data elements to make sure that payments and other services are secure. But there's another example. For example, if you do a payment on the internet, once every 3 or 4 times, you get a message on your telephone which says, can you please include this code on the payment on the web? Because your bank is actually checking that you are indeed the person that is having the credit card and is checking the phone number. Now, to be able to push those messages, of course you need to know what the phone number is, know what the screen of your telephone is, because if not, you cannot push this message to the telephone. So there are certain, what we say, security, fraud, and authentication purposes that really need to be allowed, they need to be possible. And whether we achieve that by specific exemptions or by introducing legitimate interests, that's a question of technique. But I think we first need to recognize that there are essential uses of data that are important for everybody out there.
Sure. We also already started arguing in front of the door about ePrivacy because our views of ePrivacy are very, very different. I'm very, very curious. And Helena had a life before the Mastercard. Because we were colleagues in the same department at the Dutch Data Protection Authority.
And let me tell you, Niko, we were very effective and also quite adventurous.
I have no doubt about either, my personal impression. I'm curious if you share Helena's view on the inconsistencies of ePrivacy.
So first of all, I have to respond briefly to what Axel Voss said, because there is e-privacy legislation in Europe, also for a considerable amount of time, which already imposes a very strict consent requirement with narrow exceptions. So we shouldn't talk about putting the digital revolution in the 80s framework. No, we should say maybe we've not enforced enough on the existing rules, but we definitely shouldn't throw those rules away. One of the things we can agree on is that the Working Party 29 has written a number of opinions on e-privacy when it was still in the making and once it was released by the European Commission, that the difference between consent and metadata and location data is not very helpful. Those are old school distinctions. So we propose a much more logical framework, still in keeping with the strict consent requirement and the narrow exceptions. This is actually in line with the fact that communications privacy is a different fundamental right from data protection. So it requires, in our opinion, a continued and strengthened application of sectoral rules in an e-privacy regulation, which we certainly want to see made effective as soon as possible. And it won't be the case that under the e-privacy regulation the same data will be treated under two regimes. That is already the case because the sectoral regime creates permission, like consent and some exceptions, but you still need a legal ground to process the personal data when it's personal data. So I don't see the problem. What we see as a supervisory authority, that we are being helped in this sector. There's the narrow exception of consent. That would also be the same legal ground under the GDPR. Consent in the e-privacy is consent, unambiguous consent used to be, and now consent in the GDPR. So I would like to object, and then last but not least, the comments from Helena about the exceptions. Of course there needs to be a security exception in the e-privacy regulation, and there is. If you look at the report that was voted for, adopted by the plenary European Parliament, the Libe report, contains a lot of very specific exceptions based on practice. So I don't see a problem at all with your security and location processing. Yes, please.
Before we jump, just one question to Sjoera. The Article 6 is the version that the Parliament suggested as 2 pages.
Yeah.
I find it impossible to understand. I've tried.
Well, if you look at Article 9 of the GDPR, it also contains a lot of very specific exceptions, which in national legislation compass a lot more than 2 pages.
But didn't you say before that one of the problems of legislation is it becomes too complex and confusing?
No, legislation needs to be precise. I don't think long legislation per se is incomprehensible or inapplicable. No, not at all. If you have complex legal, a complex reality, you need complex legislation to address it. Thank you.
What is your view on Article 6 and all this?
So here, my problem is I see where you're coming, Sjoera, from, in that what we have now is the ePrivacy Directive is regulating certain things. And I've had this discussion with a number of data protection authorities. I don't know, maybe we read this differently, but when I read the proposal for ePrivacy regulation, this is covering much more. The scope, as Helena has said, is much broader than what communications data, content and metadata. First of all, Article 5 talks about processing of any communication data. It doesn't talk about intercepting data. It doesn't talk about breaches of confidentiality during transmission. It talks about processing of communication data. And that can be any processing. Article 8 is not about cookies. Can we just forget that, please? It's not about cookies today. It's just we have forgotten that to implement. It's about use of information on a device and about a device. It's any device. This Fitbit, I just got this for Christmas. This is anything about this is covered by not GDPR, but ePrivacy regulation. Monitoring of employees when they're carrying tags is covered by this. And I don't know, maybe we are reading this differently, maybe we lawyers are obsessed with words, but I worry that these words mean something. And the way I read this is that the world is going to be regulated by ePrivacy. Axel, I'm completely with you. I think Helena, you and I share the same view. GDPR becomes obsolete. All this great stuff in GDPR around risk-based approach, codes, accountability, the approach which says you can process data if you've got grounds, and there are several grounds, but here we are reversing. We are saying you mustn't process data. And you know, every company will be communications company. Today, company says every company is a data company. Tomorrow, every company is communication company because everything communicates with each other. What's it called? The things you put in the eyes. The lenses are going to be communicating to my doctor because it's possible to detect whether I've got diabetes. There is no GDPR then it's only ePrivacy regulation. And to me, this is as a policymaker, Olivier, you know, I don't want to criticize Commission or anybody, but we need to think about where we are going. Where are we going as a policymaker, legislator particularly? Do we want to say everything is prohibited unless we put an exception? And then every new digital service, every new company, every new responsible use of data, we need to find another exception? Or do we want to go back to GDPR? Much smarter way to say, you can process data, but only under the following conditions. And if you do not have consent contract, then you must do legitimate interest. And guess what? It is 10 times more protective of individuals because it requires accountability. It requires you to think, is this in my interest? And what are the rights of individuals? And what am I going to do to make sure I don't pass these rights, I don't go beyond? And what are the mitigating facts I'm going to put in place? To me, that is accountability. That is real privacy protection. That's what good companies should be doing. And that's where I'm slightly worried that we are reversing that philosophy of good legislation. And let me kind of answer this question about sectoral legislation. And I've had this discussion a lot. I've had this discussion with officials in Federal Trade Commission in the past in US. One of the criticism of US I have had as a practitioner, and I used to be head of privacy for big multinational, we never liked the US sectoral approach. My US friends here, and I know many companies are with me on this, because you just don't know what data is governed by what. Health, HIPAA. Health data, when it's in the hands of a covered entity, is protected by HIPAA, but when it is not, when it's in an app, it's not covered. How is that possible? And that is something that we absolutely must avoid. And that is why we always used to say we like the comprehensive European approach, smart rules, future-proof rules, and I would like us to preserve this. And I worry, really I do worry, that with ePrivacy we are not preserving that, because we are not regulating for the future. And I think GDPR does regulate for the future.
Damian,
I have trouble with this law.
now I'm curious for the view that you are taking on ePrivacy. To be exactly that Bojana just said is complete prohibition of processing, which is new, that was not in the ePrivacy directive. The argument could be, and it makes sense to me, that when government, or we all, however you say that, want to keep control over what the digital industry, telecommunications industries are doing, the easiest thing is to prohibit everything.
privacy of the terminal equipment, and because it rests in the private sphere of the individual. The GDPR as a data protection orientated piece of legislation, so the right to data protection, is inherently different. Okay, so I mean, it aims to protect the right to data protection and other rights and freedoms in general, but it's predominantly the right to data protection. So I think some of the deviations can be linked to the very fundamental basis on which this legislation is being adopted. I think that the initial reason for this that we have is, I mean, obviously protection of the terminal equipment was always linked because it was in the private sphere. And just because something, I mean, there are connections between, I see some of the disconnections between the ePrivacy and the GDPR more in line, again, with the consent provisions. And, you know, the cookie walls, the tracking walls, and how that would align with, for instance, browser settings, how browser settings can actually lead to informed consent, and specific consent. So I think my disconnects are slightly different from your disconnects.
But can we sort of discuss this? Sorry, Niko. So you're saying we are protecting my device. But this device isn't about me. I mean, I don't need to remind this audience. I mean, the personal data definition and the way the European Court of Justice is going, examination scripts are personal data, my fridge is data about me, my phone. I mean, everything is actually personal data, so it is protected, isn't it? So what more do we need to protect about this phone than GDPR has? That's my question, right? I think we have to just write this differently.
Just assuming it's true, in fact, this is a company fraud. Whose consent is relevant and whose privacy is protected if this is a company fraud? You can do the same example with cars, etc., etc.
I mean, yeah, okay, I mean, we are talking about individual rights frameworks, so it's a fundamental right, it's an individual right, maybe confidentiality issues. So are we talking about secondary frameworks, or are we talking about primary frameworks? So I think that there is some difference there as well.
No, just to ask a very simple question, David, which I always try to get an answer to, and nobody has been able to answer me this question. I mean, you have a company that has thousands of cars, and you have provisions in the GDPR Article 8, I'm talking about, and I won't use the word cookie now intentionally, that in certain contexts you need consent. But whose consent is relevant in that case? I mean, by the letter of the privacy and the GDPR, or the way I read it, is the CEO of the company.
It's a legal person as well. That's the problem.
The person who just happens to use the car today, the person who uses the car most, who is it?
I mean, it's a difficult question. I mean, obviously, I think under the GDPR, you will need consent to process that data. Maybe I should.
Axel has an answer.
It would be nice if I would have. But I'm going a little bit further. I'm asking myself if the concept on consent is an up-to-date instrument. My thesis is consent is killing privacy, because 95% of our citizens consenting to everything because they would like to use the device, the software or app, or the free service. And even if you can save 50 cents, you will get the consent on it. And that's why I would say we have to think differently on all these aspects, and not having still the same old structure and ideas. I know consent is in the European Fundamental Rights Charter written, but I find this very old now, because we have to think differently on this.
It tends to find common grounds between the various of polar residues, Sjoera. I've often heard that from the instances of very, very critical groups of consent.
That might very well be, but let's start with the fact that consent has been undermined actively by industry. So the industry has bombarded us with meaningless consent requests. Everybody has seen the barrage of cookie pop-ups asking us to consent. This has been a conscious undermining of the consent principle. One of the good things about the GDPR is that it, for example, imposes privacy by default. The burden, which is currently fully loaded on the shoulders of citizens to just try to understand all of these consent requests and that they have to deny in order to protect their privacy, the burden is shifted thanks to the GDPR. Now all the UX creativity, the interface design creativity of these major companies is no longer focused onto tricking you to let you say yes, but they must actively invite you to say yes to processings that are unexpected, unpredictable, maybe even slightly far-reaching. And if consumers do not respond, they are protected. And the second thing about consent, which I'd like to stress, is that consent is not a free ticket for to sell your soul to the devil. Even consent has to comply with the principles of proportionality and subsidiarity. You can consent requests that are unreasonable and lead to unfair processing are invalid. So these two principles make consent still a very meaningful mechanism to give people informed choices, which is different from all the other grounds in the Article 6 of the GDPR.
One question. Is it in the nature of any consent-based privacy regulation that the burden is on the data subject? Because it is completely left up to his or her decision whether very intrusive or very harmless, it doesn't really make a difference, processes are needed.
No, not if the default setting is privacy friendly. Then you can ignore all these choices as a user. You just say, no, thank you, I'm not responding.
I won't say what every moderator say that we could go on May I then ask just whatever your question is, may I ask each one of you, I hope you can do that, for just 30 seconds.
Yeah.
As a close. Yes, please. So when you ask the question, each of you think of what you want to say in 30 seconds.
What is personal data?
I'll try to be quick. So to answer your question from my legal background, I would say, as Olivier and Micol reminded, central is the person, the physical person who is identifiable. This is the person whose consent you need, no matter who is the boss. And then I have a question for Sjoera. I work with municipalities, and before you were saying that what's in the GDPR is not new, it's just like you're kind of reframing, putting priorities, whatever. For municipalities, I would say it's a bomb, like a wake-up call, because they just got dragged into the digital revolution with smart cities, and especially in the Netherlands, which is the forefront of this kind of technology, and which we're trying to implement in Belgium as well. And so you can see municipalities have not done their homework since in Belgium 1992, that we have the data protection law.
So what is the question? Sorry.
So what would you say, like we've been talking about the private industry, but what about municipalities?
I think this would open up a completely new discussion, so I would like to ask you to sort of have this discussion afterwards.
They have to comply with the
I'm
answer.
sure we'll have a view on that, but I think it's now time for the water. Well, ladies first this time. Bojana, are you able?
Go ahead.
Is 30 seconds?
Yes, quick. Yes, I talk very fast in every language possible. So my wrap-up is this, that I think what has changed is right, you are right, is the new digital world and circumstances to which we are applying these GDPR rules. That is a huge change, and consent is not the only way to empower individuals, but transparency and the rights and the risk-based approach and the accountability of organizations. So I'd like us to focus on these 4 things rather than consent.
Helena, yours 30 seconds.
So I think my approach would be, let's
done.
make this work, and let's make it work. And so businesses, everybody needs to have clear legal frameworks. And let's not forget reality. So there are legal obligations, we have obligations to collect and process electronic communications data. And there seems to be a disconnect between the different frameworks. And I'm very happy to see that the Estonian presidency last year and the Bulgarian presidency is trying to address those. So I think we're moving in the right direction, but there's still a lot of work to do.
Sure, I know 30 seconds.
Let's not repeat the whole GDPR discussion about how GDPR is going to kill industry. Let's not, just stop saying that ePrivacy regulation will kill industry. Let's move on and let's be consistent. Please, legislators, give us a consistent mechanism.
Politicians are not known to be good for 30 seconds. So Axel, I know you can do it.
Yes, so I try my best. I would also say, yes, we should have a consistent mechanism. But data protection for me and privacy protection is not only in saying this is forbidden, this is forbidden, this is forbidden. I would say we have to think more differently, more creatively on the digital revolution and finding solutions what's combining also a future-orientated innovation with personal data. This is needed, otherwise we won't have a kind of a European self-learning algorithm because we are always forbidding something. That's why I would say we have to open up our mind and being more creative and approaching things differently.
Damian, as I know you're one of the leaders of Paris in Germany, you have the last word, but please also 30 seconds.
Yeah, so I mean, my 30 seconds really I suppose at Article 7 of the GDPR. I see the ePrivacy and Digital Content Directive, both proposals as being a challenge to this. What was gained in the GDPR
happy to have you here as our chair. Strange word for me as a German. I don't know what is for you instruction. But it's for you, the last word, the very last word, the penultimate word is yours.
Thank you very much, and thank you very much also to the very distinguished panelists. But I will use my 30 seconds as well to mention something different that Bojana very kindly already mentioned. That is to say that the Commission just published today a lot of materials in order to help both citizens and businesses, mainly those who do not have any lawyers, so the small businesses, to gain a better knowledge of the data protection rules. And if you go to use a famous browser, I will type a Commission guidance document, you will land on this page. And then we will have plenty, something like 60 question and answers on the main element of the GDPR, expressed in a non-lawyer, non-legalistic way, with examples, the links, of course, to the extremely useful guidelines prepared by the Article 39 working parties. And so we try to summarize on one page for normal human beings, non-lawyers, what data protection can mean for let's say citizen or small business. So I would like to use this opportunity. And you're most invited to comment if you find this unclear, or you would like to have more questions being dealt with, you can also submit them to us.
And Olivier, have you not given some more funding to DPAs, I heard, as well?
And we, of course, I mean, it's not all